Order. I need complete silence in this courtroom. I have presided over this bench for 23 years. In that time, I have seen tragedy walk through these doors. I have witnessed grief so profound it silenced entire rooms. I have looked into the eyes of men and women who have lost everything, their freedom, their families, their futures, all because of a single moment of poor judgment. But I have also witnessed something far more troubling than tragedy. I have witnessed arrogance. Today, we are gathered here for a sentencing that, under ordinary circumstances, would be straightforward. A young man stands before me, accused of crimes that endangered innocent lives. The evidence is clear, the witnesses have testified. The facts have been established beyond any reasonable doubt. And yet, this case is not ordinary. What happened in this courtroom over the past several weeks has tested the very foundations of the justice system I have devoted my life to protecting. A line has been crossed not just in the commission of the crimes themselves, but in the behavior exhibited within these walls. Behavior so brazen, so dismissive of the gravity of these proceedings, that I must address it directly before I deliver this sentence. To everyone present, the families, the officers, the members of the public, I want you to know that what you are about to hear is not delivered in anger. It is delivered in duty. It is delivered in the pursuit of something this defendant has openly mocked from the moment he first appeared before me. Justice. The defendant standing before me today is 24 years old. His name is Preston Elliott Chambers IV. That name carries weight in this county, weight that has been accumulated over generations through real estate development, political contributions, and a family foundation that has admittedly done considerable charitable work in our community. The Chambers family built the pediatric wing of Mercy General Hospital. Their name is etched into the cornerstone of the public library on 5th Street. They have donated 2 scholarship funds, to youth athletics programs, 2 causes that have genuinely improved lives. I acknowledge all of this, but I also acknowledge something else. This courtroom is not the pediatric wing of Mercy General. This is not a foundation gala where contributions are celebrated with champagne and applause. This is a court of law, and in a court of law, a name means nothing. A bank account means nothing. The color of your tie, the price of your watch, the connections listed in your phone, none of it matters. What matters is what you did. What matters is who you hurt. What matters is whether you are willing to stand accountable for the harm you have caused. The defendant's attorney has made numerous references throughout this trial to his client's youth, his potential, his future contributions to society. I have heard these arguments before. They are not without merit in cases where the defendant demonstrates genuine remorse, genuine understanding of the gravity of their actions. But remorse requires humility, and humility, as we have all painfully witnessed, is not something this young man possesses. I will now turn to the events that brought him before me. On the night of March 14th of this year, at approximately 11:43 in the evening, the defendant was operating a vehicle on Ridgemont Boulevard, a residential street, with a posted speed limit of 30 miles per hour. Ridgemont Boulevard is not an empty highway. It is not a racetrack. It is a street lined with family homes. There is a park on the corner of Ridgemont and Vine where children play on weekends. There is a crosswalk near the community center where elderly residents walk to their evening bingo games. On this particular night, a mother named Diana Huerta was walking her dog along the sidewalk. She had just finished a 12-hour shift at the cannery on the east side of town. She was tired. She was looking forward to getting home to her 2 children. She was not thinking about the possibility that a sports car, a vehicle worth more than she earns in 3 years, would come screaming down that residential street at 94 miles per hour. 94 miles per hour in a 30 zone. The defendant's vehicle missed Diana Huerta by less than 4 feet. The force of the passing car was so powerful that it knocked her off balance. She fell onto the pavement, scraping her palms and bruising her hip. She was lucky. 13 seconds later, the defendant lost control of the vehicle. The car spun across 2 lanes, jumped the curb, and collided with a parked minivan belonging to the Okonkwo family. Inside that minivan were child safety seats, 2 of them, because the Okonkwo family has twin 3-year-olds. Those seats were empty that night because the children were inside, asleep in their beds. If this had happened 3 hours earlier, when that minivan was in motion, when those children were strapped into their seats on the way home from their grandmother E's house, I would be standing here today discussing something far more horrific than property damage and reckless endangerment. The defendant was not injured in the crash. He emerged from the vehicle and, according to Officer Teresa Molina, the first responder on the scene, immediately began laughing. When Officer Molina approached the vehicle, she could smell alcohol. The defendant's eyes were glassy. His speech was slurred. He was swaying on his feet. She administered a field sobriety test, which he failed comprehensively. His blood alcohol level, measured 47 minutes after the crash, was .17, more than twice the legal limit. When Officer Molina informed the defendant that he was under arrest, he responded, and I am reading from her sworn report, with the following words. "Do you have any idea who my father is? You're going to lose your badge over this. I promise you that." He promised her that, a young man barely able to stand upright, having just destroyed a family's vehicle and nearly killed a mother of two, stood on that sidewalk and promised a veteran police officer that she would lose her career for doing her job. This was only the beginning. In the hours following his arrest, the defendant was processed at the county detention facility. He was offered the opportunity to call an attorney, which he did. He was treated in accordance with every protocol designed to protect his constitutional rights. And yet, during his time in holding, he made statements to the officers present that I will never forget reading. He called them servants. He told one officer, a man who spent 18 months deployed overseas before joining the force, that he would buy this building and turn it into condos just to see him unemployed. He laughed when his mugshot was taken. He asked if he could retake it because, and I quote, "the lighting was bad." But what happened next is what truly revealed the depth of this young man's contempt for the people he harmed and the system designed to hold him accountable. Within hours of posting bail, the defendant appeared on social media, not to apologize, not to express regret, not to acknowledge that he had nearly taken innocent lives. He posted a photograph. In the photograph, he is holding a champagne glass. He is smiling. Behind him, his friends are laughing. The caption, which was seen by over 400,000 people before it was deleted, read, and I quote, "Got my wrist slapped tonight. Guess daddy's lawyers are worth every penny. Back to living my best life. Try to stop me. Try to stop me." Those words have echoed in this courtroom throughout these proceedings. Those words were seen by Diana Huerta as she sat in her kitchen, still nursing the bruises on her hip. Those words were seen by the Okonkwo family as they tried to explain to their 3-year-olds why their van was destroyed. Those words were seen by Officer Molina as she prepared her testimony, wondering if anyone would care about the truth. I want the defendant to understand something. Those words changed everything, a first time. Offense with genuine remorse often results in leniency. I have given second chances to countless young people who made terrible mistakes while intoxicated. I have seen them turn their lives around. I have watched them become counselors, mentors, parents who teach their children to never repeat their errors. But you did not ask for a second chance. You mocked the very idea that you needed. 1. You stood before the world and declared yourself untouchable. Today, we test that declaration. One might desperately hope that after the events of March 14th, the defendant would have exercised caution, that he would have understood the severity of his circumstances, that he would have, at the very minimum, obeyed the conditions of his bail. Those conditions were simple. Do not consume alcohol. Do not operate a motor vehicle. Appear for all scheduled court dates. On April 2nd, 19 days after his arrest, the defendant was observed by off-duty Deputy Mark Simmons at a rooftop bar in the downtown entertainment district. The defendant was drinking. He was drinking openly, surrounded by friends who were recording videos on their phones. Deputy Simmons approached the defendant and reminded him, quietly and professionally, that he was in violation of his bail conditions. He gave him an opportunity to leave. He gave him the chance to avoid further trouble. The defendant's response was to pour his drink on the ground, look Deputy Simmons in the eye, and say, "Prove it." He ordered another. On April 9th, less than 1 week later, the defendant was photographed behind the wheel of a different vehicle, a luxury SUV registered to his mother at a gas station 15 miles from his residence. Those photographs were taken by a citizen who recognized him from the social media controversy and who was concerned enough to document what they saw. The defendant was smiling in those photographs too. When confronted with this evidence during a bail review hearing, his attorney argued that the photographs did not prove the defendant had been operating the vehicle, that merely sitting behind the wheel did not constitute a violation. I denied the argument. I revoked his bail. And for the first time in these proceedings, I saw something other than amusement on the defendant's face. I saw anger. He turned to his father, sitting in the gallery, and said words loud enough for half the courtroom to hear. "I told you to fix this. What am I paying you people for?" I had him removed, not because I was offended, though I was, not because I was angry, though I was that too. I had him removed because in that moment I understood exactly who I was dealing with. I was dealing with someone who had never, in 24 years of life, been told, "No, I want to speak now," not as a judge reading from legal precedent, but as a human being who has spent more than 2 decades trying to understand the difference between justice and punishment. They are not the same thing. Punishment is easy. Punishment is a number, days, dollars, demerits. Punishment is mechanical. It can be calculated, appealed, reduced. Justice is harder. Justice requires that I look at the defendant before me and ask a question that has no simple answer. What does this person need to hear? What does this person need to experience? What, if anything, might reach them before they destroy their own life or, worse, take someone else's? In my years on this bench, I have granted mercy to people who did not seem to deserve it. I have reduced sentences for defendants who wept in front of me, who promised to change, who swore on the graves of their parents that they understood the gravity of what they had done. And some of them were lying. I know that. I knew it when I signed the papers. I knew it when I watched them walk out of this courtroom with lighter sentences than the law allowed. But I did it anyway, not because I was foolish, but because mercy is the risk we take when we believe in redemption. The question I must answer today is whether mercy would serve any purpose in this case. I have thought about this for many sleepless nights. I have reviewed the evidence again and again. I have read the defendant's personal statement, submitted by his attorney. I have examined the letters of support from family friends, from former teachers, from employers who describe him as bright and capable and full of potential. I do not doubt that he is capable. I do not doubt that he possesses potential. But capability without conscience is dangerous. Potential without humility is destructive. I have seen young people who grew up with nothing, no money, no connections, no safety net, who made one mistake and begged for the chance to prove they could be better. Some of them are now contributing members of society. Some of them mentor at-risk youth. Some of them have written me letters, years later, thanking me for the second chance. I cannot in good conscience give the same consideration to someone who has been given every advantage in life and responded with contempt. This defendant does not need mercy. He needs consequences. For the first time in his life, he needs to understand that the rules apply to him too. Before I deliver this sentence, I must address something that occurred outside the view of the public, something that has weighed heavily on me throughout these proceedings. 3 weeks ago, I received a phone call. The caller identified himself as a representative of the Chambers Family Foundation. He expressed appreciation for my years of service to the county. He mentioned that the foundation was considering a substantial donation to the Judicial Employee Wellness Fund, a fund that supports mental health resources for court staff, for bailiffs, for the public defenders who work tirelessly for minimal compensation. It was a generous offer. It was also, transparently, an attempt to purchase favorable treatment for the defendant. I declined the offer. 2 days later, I received a letter on official stationery from a state senator's office expressing concern about the direction of this case and urging me to consider the broader implications of excessive sentencing. On promising young citizens, I did not respond to the letter. Last week, I learned that the Defendant'S family had retained a public relations firm to manage the narrative surrounding this case. Articles began appearing in local media outlets suggesting that the defendant was being unfairly targeted because of his family's wealth. Opinion pieces questioned whether my judgment had been compromised by personal bias. I want to be very clear about something. I do not care about the defendant's family wealth. I do not care about political connections. I do not care about op-eds, about public relations campaigns, about foundation donations offered in exchange for leniency. This courtroom is not for sale. The scales of justice are not weighted by bank accounts. Every phone call, every letter, every attempt to manipulate these proceedings has been documented and forwarded to the appropriate oversight authorities. I want the defendant and his family to understand that these efforts did not help his case. They confirmed everything I already suspected. They confirmed that this family believes the rules do not apply to them. Today, I prove otherwise. Will the defendant please rise? Preston Elliott Chambers, 4. You have been found guilty of the following charges: driving under the influence of alcohol, reckless endangerment, destruction of property, evading lawful orders, and contempt of court. Each of these charges carries its own weight. Together, they paint a portrait of someone who has demonstrated not just poor judgment, but active disdain for the safety of others and the authority of this court. I am now prepared to deliver your sentence. For the charge of driving under the influence of alcohol, I sentence you to 18 months in the county correctional facility. For the charge of reckless endangerment, I sentence you to an additional 12 months to be served consecutively. For the charge of destruction of property, I order you to pay full restitution to the Okonkwo family in the amount of $47,000, the full replacement value of the vehicle you destroyed. For the charge of evading lawful orders and violating the conditions of your bail, I sentence you to an additional 6 months to be served consecutively. For contempt of court for your behavior in this courtroom, for your public mockery of these proceedings, for your disruption of judicial process, I sentence you to 90 days to be served consecutively. In total, you will serve 39 months in the county correctional facility. Additionally, upon your release, your driver's license will be suspended for a period of 5 years. You will complete 400 hours of community service, specifically with organizations that support victims of drunk driving. You will attend and complete an alcohol education and rehabilitation program. You will be subject to random drug and alcohol testing for a period of 3 years following your release. You will also issue a written public apology reviewed and approved by this court to Officer Teresa Molina, to Diana Huerta, and to the Okonkwo family. This apology will be published in the same outlets that carried your mocking social media posts. I want you to understand why I have imposed this sentence. This is not about revenge. This is not about making an example. This is about holding you accountable for the harm you have caused and the attitude you have displayed. You nearly killed innocent people. When given the opportunity to show remorse, you laughed. When given the opportunity to comply with the court's orders, you defied them. When given every chance to demonstrate that you understood the seriousness of your actions, you posted photographs of yourself celebrating. 39 months is not a death sentence. It is not the end of your life. When you emerge from custody, you will still be young. You will still have opportunities that most people never receive. But you will carry this record with you. And perhaps, just perhaps, that will make you think twice before you endanger innocent lives again. Before I conclude, I want to address the gallery. I see parents in this room. I see young people. I see families who came today seeking answers, seeking closure, seeking some assurance that the system works. I want to speak to you directly. To the young people, I know that you are watching. I know that some of you may recognize elements of yourselves in this defendant, the feeling that the rules are arbitrary, that authority figures are unfair, that your youth and your potential should shield you from consequences. I am here to tell you that this is a lie. The rules are not arbitrary. They exist because human beings are fragile. Because a car traveling at 90 miles per hour becomes a weapon. Because a moment of recklessness can erase decades of future. Because the families shattered by preventable tragedy never fully recover. You are not invincible. Your future is not guaranteed. Every choice you make has weight. To the parents, I know that you love your children. I know that your instinct is to protect them, to shield them from hardship, to use every resource at your disposal to give them advantages. But protection is not the same as preparation. A child who never faces consequences does not become a confident adult. They become a dangerous one. They become someone who believes the world exists to serve them, and when it doesn't, they lash out. The greatest gift you can give your child is not comfort. It is accountability. It is the understanding that their actions matter, that other people matter, that the world does not revolve around their desires. The defendant's parents are present in this courtroom. I do not know them personally. I cannot speak to their intentions or their efforts. But I can say this. Somewhere along the way, something went wrong. Somewhere, the message was lost. Somewhere, this young man came to believe that the rules existed for other people, and that belief has brought him here, facing years in a correctional facility. I sincerely hope that when he emerges, he will have learned what no one else was able to teach him. We have reached the end of these proceedings. I want to acknowledge the courage of those who came forward. Diana Huerta, who agreed to testify despite the intimidation she faced. The Okonkwo family, who sat through days of testimony, reliving the night their vehicle was destroyed. Officer Teresa Molina, who did her job with professionalism and integrity despite being threatened and mocked. You are the reason this system works. You are the reason justice remains possible to the defendant. I take no pleasure in this sentence. I take no satisfaction in seeing a young person's freedom restricted. But I will not apologize for doing what the law requires, for doing what justice demands. When you walk out of that correctional facility in 39 months, you will have a choice to make. You can emerge bitter, resentful, convinced that the world treated you unfairly. Or you can emerge changed with the understanding that your actions have consequences, that other people's lives have value, that arrogance is not strength. The choice will be yours. Today, my choice is made. The defendant is remanded into custody immediately. Bailiff, please escort Mr. Chambers from the courtroom. This court is adjourned.